Good afternoon, everyone. Welcome to today's webinar on succession law. I'm delighted once again to host Jackie Oyuyo-Givenji, my classmate and friend. Joining me as well is Salome Asena and John Sunday, my very able and dedicated colleagues. I know we had shared Jackie's bio, but I just want to do justice to her by reading it out once again. Jackie is the managing partner at Umsizi LLP and has considerable experience in a broad range of corporate, commercial, and family matters from her more than 20 years practice in various sectors. A chartered arbitrator, she's a fellow of the Chartered Institute of Arbitrators and a certified and court-accredited mediator. Jackie serves as non-executive director on various boards, notably as chairperson of the Nairobi Center for International Arbitration, NCIA. She has played a critical role in the development of a national policy on ADR, basically alternative dispute resolution in Kenya, and is a regular speaker in the areas of arbitration, mediation, and corporate governance. Jackie has served as a third-party neutral in a number of domestic and international commercial disputes, and is recognized in the Legal 500 Arbitration Power List Africa and Leaders in Law, Corporate Law Kenya Global Awards. In addition to teaching various undergraduate courses in ADR, she's a certified tutor with the Chartered Institute of Arbitrators and a contributing author to the International and Comparative Legal Guides annual publication on litigation and ADR. So this afternoon, we're in very good hands. Today's topic has generated a lot of chatter and interest online, and we will try our best to ensure that some, if not all, the issues you have raised are addressed. Before we begin, let me just point out a few housekeeping rules. Number one, please direct all your questions in the Q&A section to make it easier for my team and I to trace them. Kindly keep it short and simple. We'll be conducting a poll midway through the conversation, and we look forward to your participation. Third, this session is streaming live on Facebook, so you can also join us on the said platform in the event that you have to get moving at some point. So let's get started then by looking at a few definitions within the context of succession law. Jackie, many people are curious to know, what is succession law?
Thank you, Helen, and thank you to everyone who's joining us today. Good afternoon, those of you in Kenya. Good morning, good evening, anyone else joining us from outside of Kenya. Estate planning is one of those phrases that perhaps people think does not apply to them, because when you talk about an estate, then we'll think dynasties, right? We'll think extremely wealthy who have a lot of investments, a lot of money, they're cash rich, they have a lot of land to dispose of, they have investments that they need to dispose of, in the event of their demise. But estate planning, simply put, an estate is anything you own outright, whether it's a vehicle, your personal effects, your phone, your land if you have it, cash and cash equivalents, investments, your pension, insurance policies, anything that your name is attached to as an owner, and that is then no third party has a claim to. So that is your estate in the simplest form. And estate planning then is what you do to make sure that in the event of your demise, and that's the way of all of us, then that estate is managed, administered, and distributed in the way that you want. And to be honest, Helen, estate planning starts long before we even realize it. Anytime you fill a beneficiary form, for example, in the course of your employment, that is estate planning. Anytime, even in the gym, for example, you give the name of the next of kin, or when you're boarding a flight, you're asked to say who is your next of kin, that is estate planning. Because in the event of anything happening to you, that is the first port of call in terms of that agency then looking for the person who is next in line to communicate to you. First of all, the circumstances of your demise or your incapacitation, and then of course, what to do in the event that you are no longer with us. So in a very simple form, estate planning is deciding when you're still alive, what should happen to your property when you are no longer with us.
So let's get into the area of tested and intested.
What
does it mean when we say someone has died tested and or has died intested?
Okay. These words are words that, let me call them legal jargon, because they're not necessarily words that you hear on a daily basis, which I guess is the reason we're both laughing. So let's start from the end, and the end is death, right? Let's all agree that death is the logical conclusion to your physical life. And I'm being very deliberate about saying physical life because, we could get into all sorts of cultural and religious views on what happens to your soul. But let's talk about the physical life. This is what we have time for this afternoon. So if death is the logical conclusion of your physical life, do we need to plan for it? Should we care what happens to our property beyond our lifetime? Depending on what your views are in terms of those two questions, then you will either die testate or you will die intestate. Testate simply means that at the time of your death, you have written a will, or there is a will that has indicated the way in which you want your property disposed of. Intestate is the opposite of that. It means there is nothing on record, whether orally, which is verbal, or in writing to indicate how you want your assets disposed of beyond your physical lifetime. So when you hear people talking about testacy and intestacy, that is simply what they mean. You either died with a will or you died without a will. That is the most basic definition of those two terms.
Okay, so even as you write this will or decide I'll bequeath this and that to the other, you have to have someone, or either a person, as in an individual, or a corporate person that you will be bequeathing this to. So when you look at beneficiaries, who exactly are beneficiaries? Do they have to be living persons, as in Helen and Jackie, or can they be Umsizi LLP or USIU Africa? So
or
who is a beneficiary?
A pet.
Okay. Yeah, or my pet, Naila,
So your beneficiary is anybody, and I use this term loosely because legal person can be defined in the way you've described. It can be a physical human being, such as you and I, or it can be an entity that you then bequeath a portion of your assets, or indeed all of your assets. So a beneficiary is anybody you intend to benefit from your estate in the event that you are no longer here. So by way of example, I could decide I want my personal effects, to go to my sister, or I want the cash that is in my savings account to go to my mother, or I want the books that are in my custody and ownership to go to a library. So it does not have to be a physical human being. It could be also a legal entity. All that is required is that we are able to determine with certainty who that beneficiary is supposed to be. So if you just say, I want it to go to a library in Nairobi, I want my books to go to a library in Nairobi, then you leave it to chance in terms of which library. Do we go to the National Library? Do we go to Macmillan? The element of certainty is what has to be clear in terms of your will. If you say that I want my personal effects to go to my sister, if you have more than one sister, which one? Or is it all of them? So whatever it is that you've determined to be a beneficiary, whether it's a human being, a natural person, or a more corporate entity, you just have to be clear in terms of saying with certainty who that beneficiary is.
Okay, thank you. So now we are getting legal. What is probate?
Okay, before I go to probate, let me go back a little bit to the law, the most overarching law that governs succession planning in this country, or succession law. And that is the Law of Succession Act, which is Chapter 160 of the laws of Kenya. And before I get into that deep dive legal discussion, I need to distinguish different branches of law. So the whole concept of personal law, which is where succession law falls, is those laws that apply to a particular person or a class of persons wherever they are situated. So, for example, if I am a Christian in Kenya, which are the laws that apply to me? If I am a Muslim in Kenya, or a Hindu in Kenya, or I'm agnostic, which are the laws that apply to me? That personal law is distinguished from territorial law. So I could be an American living in Kenya, but there are certain laws that will not apply to me because my personal law then kicks in. But there are certain laws that will apply irrespective of my nationality. So for example, the traffic laws are territorial laws. They apply. As long as I'm sitting in traffic and driving a motor vehicle in Kenya, the traffic laws will apply to me. But now if we flip that coin and talk about personal law, then if we're talking about, for example, and these are matters that are personal to you, right? Your marriage, your children, succession, these are laws that apply to you because of how you are classified in Kenya. So culturally, based on ethnicity, religion, faith, these are the laws that will apply. So for example, in the past, most of us Africans in Kenya who got married in Kenya were married under the African Christian Marriage and Divorce Act. And this harks back to colonial times when, depending on your caste, so to speak, or your race, then you could only be married within certain streams of law. If you are a Hindu, then certain laws applied. If you are Muslim, certain laws applied. But in 2014, there was an attempt to then consolidate and amend all those marriage laws in Kenya so that they are all couched in one act, which is the Marriage Act of 2014. And this act recognizes different types of marriage, whether it's customary, whether it's civil, whether it's religious, so then Christian, Hindu, or Muslim, and then provides an overarching act for all those types of marriage. Within that, then, you can register your marriage. So Part 9 of the Marriage Act then encourages us all to make sure our marriages are registered. So even if you're customarily married, the Act guides in terms of how to then ensure that, at least at the registrar of marriages, there is an entry that you are married under this particular set of laws. And this becomes important in the context then of succession. And then how you can make a will, for example. And this is where probate comes in, back to your original question. This is where administration of your estate, if you die intestate, basically if you don't have a will, how that kicks in. So inevitably, the Succession Act is going to be a factor in all of our lives, whether we have a will or not. The Marriage Act, if to the extent that you're married, is going to be a factor in all of our lives. And these are the personal laws that I say apply because of how you are classified as an individual. So when we talk about probate, we're simply talking about the process then of the recognition of your will. And I know sometimes, people talk about probate in both the concept of intestacy, which is with a will, or intestacy without a will. But strictly speaking, probate applies to that process that then kicks in at the point when you die and you've left a will, and what the steps are towards enforcing that will. So that process of and leading to enforcement is what we call in legal terms the confirmation of grant of probate. And the Act, the Succession Act that I've mentioned, gives a guideline, and the regulations under that Act gives a guideline in terms of how that probate, step-by-step process for that probate. And typically, because many of us who are non-lawyers are not conversant with the court system, for example, we will engage a lawyer to assist us with that process of confirmation of grant, because it can be quite tedious. And if there's, for example, a challenge to the will, then that will be a detour, so to speak, in the process of confirmation of grant, because ultimately the will is supposed to take care of everybody who is dependent on you. Now, if somebody feels that they were dependent but have not been catered for in the will, then they can challenge the will, and then there will be a delay in terms of the confirmation of the grant of probate.
Excuse me, Jackie, could you please adjust your mic? You're fading in and out.
Okay. I hope that's better.
Yes.
Okay,
Yes.
thank you. All right.
Yeah, so you moved straight into where I wanted to go next. What
Okay.
is a will, and how does how does one go about getting one? Should it be verbal, as in oral? I tell all my dependents, okay, I give you this, I give you that, I give you the other. Or would you recommend that it should be something that is in writing, because we have we've heard of all these cases where a child comes and says, oh, he gave me this, another one comes with another and said, no, here's the will, he wrote it down and gave me this. So how do we go about that? And just before you answer that, participants, we have the first poll on now. You can answer the questions as Jackie takes us through what a will is and how we can go about getting one.
Okay, thank you, Helen. So a will is your expression of how you want your property, your assets, distributed or managed after you are no longer with us in this realm. So a will is basically your final intention as to how your property should be administered and distributed to your beneficiaries. And the will may take two forms under the Succession Act. The Succession Act recognizes either the oral wills, which are verbal, or the written wills, both of which will require that you have witnesses. Now, the only caveat with the oral will before you all go deciding that, oh, okay, I don't need to write anything, it's only valid for 3 months from the date you state what you wanted to see. So if I say today, 31st of August, that I want Helen, I bequeath all my money to Helen, that is only, first of all, there have to be 2 witnesses present who have heard me say that I want to bequeath my money to Helen. And then secondly, it is only valid until 3 months from today. So in another September, October, November, by the 1st of December, that oral will is no longer valid. So obviously, to give a longer term effect to your wishes, you ideally want your will to be in writing. You want to give certainty in terms of, first of all, clarity on all the assets that you have, because let's face it, sometimes even that we forget, you may have something you invested in a while ago and you've actually forgotten that you had invested in it. So it actually takes some effort on your part in terms of identifying all your assets. And let me just say something about identifying these assets. There are some things we never consider when we're talking about assets, because especially in our African context, we are cultured to give value or attach value to certain things. So cash, for example, we always assume that's an asset, and anything that's equivalent to cash. So your money, your investments, your shares, any pension that you have the benefit of, any insurance policies, any savings, that sort of thing. We are clear that those are assets. But also, we have to start to consider different classes. For example, your M-Pesa balance, right? Mm-hmm. It's an asset, which not everybody will have access to. I mean, unless you have children who have your PIN, for example. Nobody else knows how much, besides Safaricom or Airtel, nobody else knows how much is in your balance. And that's cash, right? We don't think about it, we should. Other assets that we don't think about are things that are personal to us. And then some of these personal effects have what can be given an immediate value. Like if you have a laptop, for example, it would be easy based on just common depreciation to determine the value of that laptop. But then there are other things that have value to you, but may not have value to anybody else. For example, your childhood photographs or your family heirlooms. Maybe you have a 3-legged stool that was bequeathed to your grandfather in certain circumstances. It may not be of value to some people, but it is of value to you. So we have to have a broader thinking of what we consider assets. Away from what we could call cash and cash equivalent assets, we also need to think through, and this is especially for people in the creative industry, your literary works, your artistic expressions. You have collected, and not as a collector, but as the actual creative. You are, for example, a film producer. Which of these films are attributed to your name. And of course, now, the intellectual property then comes in terms of, do you have copyright in those literary works, whether it's a book you've authored, a painting you've created, some other artwork that you've created. And then, of course, in the IT space, any digital works that, are fully ascribed to you in terms of ownership, music, if you have ownership in those literary works, those are assets that you need to consider also among your property. And to put it in perspective, the late great Michael Jackson has made more money dead than he did alive. As reported in 2021, his estate has made over 2 billion United States dollars since his death in 2009. Now, if many of you may remember, and I'm exposing my age, which is fine, that at some point he was literally about to file for bankruptcy. But look at the work that his estate is now doing in terms of licensing, the sampling of his music or even unreleased music, for which I understand there's a huge library, his personal effects, his clothing, his endorsements. So especially if you're in the creative space, think beyond what you traditionally know to be your assets, to think through also what you have created and what is particularly ascribed to you as a property owner beyond just the typical land, cash sort of definition of assets. Think through also the other things that you have created that you own and that have value and can now, at least in the current space that we live in, can actually be valued and a value ascribed to your estate. So as you start to think through these assets, you start to see that there's a lot you have to think through. It's not just what we've traditionally been accustomed to. So your will catalog all your assets. In addition to that, you want to think through the distribution. So on the one hand, you have maybe on the left-hand side, you have your assets. On the right-hand side, you have the list of potential beneficiaries. How do you start to match those assets to beneficiaries in different proportions? And like I said, when we talk about wealth, let's not think about wealth in terms of astronomical wealth. Let's just think about what is real to us, what we own as individuals, including your personal effects. You may have a view on who should, for example, have access to, your most intimate possessions that you wouldn't want, people just to, as sometimes happens in some cultures. The first thing when somebody has died, especially a matriarch or a patriarch, is the siblings or other people come in and they want to start, gathering clothes and things like that. But there may be things in the family that, have sentimental value. So as you think about assets, think also of those things that have sentimental value to you, in addition to those that can either that have a monetary value or can continue to generate monetary value for future generations. So once you have that in mind, then you want to think through, the two concepts you've introduced, Helen, which is the beneficiaries, as I've indicated. You want to think through the distribution of assets to those beneficiaries. And in that concept, then you start to think, who can I bequeath? And we've sort of talked a little bit about that. And then who must I bequeath? So the Succession Act says, for example, that your dependents ought to be taken care of, and it defines your dependents. And until 2021, I think it was November, when Honorable Kaluma introduced an amendment, the act was clear when it spoke about your spouse or former spouse. But there was an amendment that attempted to exclude former spouse. And I believe there's still going to be some jurisprudence around that and some litigation around that. Because if, for example, I'm your former spouse, but you are taking care of me, then it shouldn't terminate with your death. The rule of thumb, basically, if I was accustomed to you taking care of me in a certain way, then I should not be deprived of that, benefit on your demise, basically. Of course, there's a lot of case law around this. And like I said, some of it spills over from the marriage space. But we can certainly talk about that for a long time to come. So in addition to these beneficiaries and your assets, there are sort of, let me say, practical things that the Act talks about. And some of them may not make sense to you, and I'll explain why. The Act says that your will, if it's written, and it should be, as I've said, should be witnessed in order to be valid. And the way this is done, it is attested by 2 or more witnesses, and the witnesses have to be competent. Again, we'll talk about that. Now, each of these witnesses has to have seen you sign the will, not necessarily in each other's presence. So you can already see the ridiculousness of that provision, because unless I'm going to keep signing my will every time I want somebody to witness it, then we kind of all have to be in the same room at the same time when this is happening. And it's complicated a little bit further by the fact that if I am a witness and I'm also a beneficiary, then somebody has to witness my witnessing. This is why they say 2 or more competent witnesses. So for practical reasons, I generally say avoid having as your witnesses people who are going to be your beneficiaries or people who are going to be your executors. And I know you'll introduce that concept later. But ideally, just have independent people who don't stand to gain anything from your will witness your will. And ideally, let them read at the same time so that one will say, oh, I witnessed, but I didn't see Jackie signing. So that then takes care of this provision that the witnesses have to have seen you sign the will, and they have to have done it, have to witness your will in your presence.
Okay. So you said something that's very interesting, and I want us to go back to it. So if I bequeath my, let's say, unfinished manuscript to my niece, for instance, and then she ends up making a lot of money from the book when it's published. Are there other beneficiaries who will feel disgruntled that she appears to have gained more from whatever Auntie Helen gave?
Well, Auntie Helen, they may, but that's the intention you expressed, unless you then go into some level of detail. And this is where perhaps having a lawyer assist you comes in. You know, you could just say, I want my, as you've said, I want my unfinished manuscript to go to my niece. And then your niece decides, wait, I know Auntie Helen always wanted this book finished and wanted it published. And as you've said, then some income starts to derive from there. Unless you have indicated in your will the manner in which that income should be distributed, then as much as people are disgruntled, that is really all they can be, disgruntled. Because that particular bequest, that particular gift was gifted to your niece for her benefit.
Okay, thank you. You said something about, I want to stay on that issue of beneficiaries. Something about I have to catalog everything, okay? And who it will go to. So if I say, like, I want all my property to go to my dog, the validity in that. And as you answer that, there's a question from John about whether this will must be in legal language or normal lingua will do.
Okay.
I think John is trying to avoid paying lawyers' fees. John, we see you.
So the validity of your bequest, yes, you can give your pet whatever you want to give your pet. The trick, of course, will be when you're no longer here, how your executor then manages that intention for you to bequeath, for your pet to benefit, you know, in perpetuity, which also raises the question of who then benefits when the pet dies. But again, these are things that should be contemplated in the will. If a beneficiary dies before you or dies, you know, within a certain time, then what happens to your estate? Basically, your residual estate, and I'll talk about that a little later. It's valid, in fact, as your executor. When you're selecting an executor, an executor is basically the person who brings your intentions to life. And they don't need to be anybody that is related to you. They don't need to be somebody that is a friend. They're really just the person who you trust to give life to your intentions. And just as a practical piece of advice, I would just say, look for somebody who, number one, you trust, and number two, is very dispassionate about the things that you want to do. I should not have a view, if I'm your executor, that you have chosen to, you know, give your dog all your property. I should just make sure that your dog then gets all your property. Basically, look for somebody who will independently indulge your eccentricities, and make sure that they first of all notify the people who need to be notified that you have a will, because otherwise other people might not know. So somebody you trust and somebody you know will give effect to your wishes. As to the language, John, the simpler the language, the better, because people have to be able to interpret it in the manner you intended, and then to give effect in the manner that you intended. So it doesn't have to be in any legal language. In fact, the Act does say there is no prescribed form for a will. It just needs to be clear in terms of your property and your beneficiaries. So no tricks or templates, so to speak. But of course, if you're seeking legal advice, I'm sure the lawyers will already have a way that they've drafted previous wills that they know have been enforced without any challenge. So they may have certain advice they give specifically to make sure that effect is given to your intentions. But the short answer, there's no specific language.
Okay, so, but then we get to the issue of, so you've talked about what would make it legal and binding, but there are instances where, you know, it can be revoked, can be varied. I hear some people, when I brought up this issue about this webinar, somebody told me that they have a will, but they've never like really finalized it, because every time their child does this or the other, or a beneficiary annoys them, they, you know, like just omit them from the will. So can we talk about that from the perspective of revocation and varying of wills? And maybe you could talk a little bit about revocable and irrevocable trusts. Or have I jumped the gun here? I've gone straight to trusts, but let's finish with the wills first. Yeah.
Okay. So with the wills, because it's your intention, you know, we are allowed to change our minds. They say women and cats are allowed to change their minds, and dogs and men just have to live with it. You can change your mind at any time. You just have to make sure, and this is why you will see, and perhaps, John, this is where the legal language comes in. The sort of opening paragraph of most wills you will make a declaration that you revoke any former wills. And this is just to make sure that there is not one dated 31st August 2022 and then another one is found on 2nd September 2022. We will know with certainty that on 2nd September 2022, you revoked the will that was there as at 31st August 2022. And for the reasons Helen has mentioned, which is basically you've changed your mind, or maybe you've acquired new assets, or you've even disposed of certain assets, they're no longer in your catalog of property, or, and this has happened, you know, in a practical way, you lose one of your beneficiaries. You know, your beneficiary predeceases you. So you then have to possibly redistribute your estate to the extent that you had not contemplated any of your beneficiaries predeceasing you. And this happens quite often, incidentally. So you can revoke at any time, provided that you have made it clear that this current version revokes any previous versions. This is the version that is prevailing, you know, so that at the time of your death, even your executor is clear, this is the version that's prevailing at the time of your death, and this is the way your estate should be administered now that you are no longer here to personally, of course, declare that intention. I don't know if you want me to go into trusts or if there are any other questions that relate specifically to wills before then we talk about trusts.
Yeah, let's stay with the wills just a little bit.
Okay.
So this will, who's supposed to be having it? Who takes custody of this will, and how do the beneficiaries under this will know? Is it my responsibility as the maker of the will to notify my beneficiaries that I have a will and it's with the Jackie Oyuyo Githinji at Umsizi LLP, or is this something they'll discover after I'm long dead and they have basically squandered my estate?
That's a very good question, because for a long time, people didn't tell people they had wills because they didn't want these potential beneficiaries to kill them. In fact, when I worked in the insurance industry, it was very interesting that for most people, especially from a certain community that I wouldn't name, when they nominated their beneficiaries, they never, and these are men, they never nominated their wives. They would always nominate their mothers. You know, that just speaks to perhaps the levels of trust that we have amongst us in this country. But it is important that you tell your intended beneficiaries, to the extent that you feel you can trust them, and you should if they're benefiting from it, that you have a will. The risk, of course, is that you have chosen an executor who will not say anything, though there is a duty on them to disclose. Your executor is the person who steps in immediately on your demise. Because, and the thing I should have mentioned at the beginning, your will is not just about your assets. Your will can also talk about how you intend your physical remains to be disposed, for example. So before people start forming committees to decide that you are being buried on the 19th of September in Funyula constituency, and they've even decided the direction in which your head should face the homestead, you may have decided that you want to be cremated within 48 hours of your demise. That needs to be communicated so that your wishes are fulfilled. So in addition to that property distribution, there's also subtle and some not so subtle. They're actually important. The means through which you want your remains to be disposed. And these days, people are getting really creative. I think you'll remember the late Professor Wangari Maathai. When she passed on, there were specifications even as to the coffin, right? Because it had to be sustainable because of her whole passion for the environment. So I think it was a bamboo frame and a papyrus casket, and she was then, I think after the whatever ceremony, there was a private cremation, right? And we're seeing this increasingly with the prominent people in our society who are choosing to go the cremation way, as much as it may be, completely inconceivable from a cultural perspective, but we're seeing that more and more. If you look even across the globe, there are even very interesting instances where you can say, because of, again, you think through the whole circle of life and how you don't want to be a detriment to the environment even when you're gone. Then there are people who say my ashes, for example, should be composted into, they have this, what they're calling now sustainable forests, where your ashes form the compost for these forests. So you can be very specific in terms of how you want your remains to be dealt with. You can also be very specific, and this is a sensitive one, especially if you're a parent, but you want to be clear about how your minor children should be taken care of. And I don't just mean financially, but who will take care of them. If both you and your spouse are no longer there, if you're in a marriage situation, if you're a single parent, even more important, who is going to take care of your children? Who will be the guardian for your children when you're no longer here? So beyond just the property, there are all these, let me say, soft issues that we need to consider. In addition to that, it could talk about any sort of charitable works that you want to be funded from your estate. So little nuances, and I'm calling them little, but they're actually big deal. Who takes care of your children beyond you is a big deal. How you're disposed of, at least to you, may be a big deal. I mean, there are people who don't care. They say, I'm no longer here, so I really don't care what people do with my body after I'm gone. But these are some of the things then that you need to take into account. So then back to the whole question of who should know. Your executor certainly should tell everybody that needs to know, and they will know, because even the way the will is handled is a very private affair. It's not something that, oh, now hear ye all, please come forward. It is only for the people who need to know about what was in your will. So it's not necessarily the whole clan has to be called and involved. No. It is really just your beneficiaries. And then, there may be certain timelines built into it. Like if you had said you wanted to be cremated within 48 hours, then that has to be honored. If you had said that there are certain third parties that need to be notified, then that needs to be done in the manner you intended. Of course, if there's a challenge to the will, like I mentioned in the beginning, then this puts a pause on everything. And I'm sure you've seen situations where these tussles, especially around bodies, then become so significant because people believe that if I bury the person, then I have the right to inherit, So always better to have a will than not to have it. So that it's then a question of the person challenging it, proving that that was not your intention, as opposed to people trying to infer what your intentions could have been.
Okay, so it's through some of these, I want to call them like advances, you're calling them nuances, but they're advanced nuances. Because you even see somebody like reading their own eulogy at their funeral, because they planned all this beforehand. Or they'll say that they don't even want a funeral service, they want a celebration at the place they used to like hanging out. So, like very intricate, advanced nuances that, help you to remember this person that's gone without, a lot of sorrow. Okay, thank you. So then we move on to trust. I'll go back to wills at some point because I want us to get into this subject of executors, executrix, writing out someone from a will, whether I have the obligation to notify them. So, but let's just go first to trust. So what is a trust and how is it set up? And what is considered as an asset that is not trust property?
Okay, so maybe as I'm responding on the question of trust, then Salome, you can put up the third poll, which will speak to the question you asked immediately prior. So a trust is essentially a perpetual entity that will typically manage sort of charitable purposes, and they're specific. It's the advancement of religion, the promotion of education, health, and very specific charitable purposes.
Hello?
And then, yes?
Yes.
Salome,
Okay.
please. Salome, please mute your mic.
Sorry about that, I'm muted.
Okay, so Salome, it's the third question, rather than these two. And I'm happy to see that most of us think wills are necessary, but then very few of us actually have them. So maybe by the end of this webinar, we'll have a different take on whether we should have them or not. So Salome, then the third question is what you can share while I respond on the question of trusts. So a trust, and in this country, trusts are administered under what we call the Trustee Perpetual Succession Act, which enables a corporate entity to be set up outside of the company's regime. So it's a corporate entity, it has a legal life of its own, and it exists, as the name suggests, in perpetuity. So this trust can own property, it can distribute property. Basically, it can act almost like an individual. It can invest property, it can own land, and sometimes this is the distinction, perhaps with the typical charitable organization. It can invest in land, it can then agree on distribution of investments and things like that. So when you set up a trust, and I suppose this is what you were talking about when you were talking about irrevocable, Helen. So a trust is intended to continue, as I've said, forever and ever. And typically you will appoint, or you will have a mechanism by which trustees will be appointed, and they may be appointed in sort of an official capacity. Like you can say, I want one of the trustees to be the vice chancellor from time to time of USIU Africa. And so the person holding that seat then will always be a trustee on that particular trust. And just to put it into context for our audience, a lot of charitable organizations that exist across the globe today are indeed this type of irrevocable trust. When you think about, for example, the Rockefeller Foundation, you think about a lot of these big foundations, the Ford Foundation, they sort of had these early beginnings, as trusts, and then developed very specific objectives that they wanted to execute, and then very specific again around how they're executed. Trustee law is generally very strict. They call, even in terms of how you're going to change trustees going, from day to day, you will have, it's not just a simple thing. So it's something you think through. And again, this is something you would want to sit down with a legal advisor to advise you in terms of how to set it up, and think through why you're setting it up. Is it something, if it's something you want to continue to support, say it's a charitable organization that you want to continue to support through your trust, or you want to create bursaries or for specific educational purposes, or even because you have a passion for agriculture, you want your funds to go into specifically agribusiness, or things like that, things you're passionate about. Basically, people use these trusts to finance the things they're passionate about. It could also be for health objectives, for example, maybe because you have been touched in some way by specific disease, you then set up this trust so that you can continue to fund research into that disease. So this is why they tend to be irrevocable, because they have, let me say, larger than life, excuse the pun, but larger than you, the objectives that are beyond you, and that you're then enlisting other people to help you administer. I think that's the most high level, simplest definition I can give of irrevocable trust. Otherwise, I'll get very legalistic and lose you all.
Yes, and before we get very legalist and lose everybody, I wanted us to go back to wills. There are some questions in Q&A. On so Professor Martin Joroge, I think that's the first question. What if I write a will in Kenya, but I die in the USA, for example? Will my will on who I leave what be respected in the US? What does international law say about respecting a person's will, especially upon their death?
Okay, thank you. Do you want me to answer that or take a few?
Yeah, just answer that. We'll go step by step. Okay,
so that's a very good question. And it goes back to one of the opening statements I made around personal law. The question you've asked is actually a very intellectual question, because it goes to what we call private international law. And private international law governs your personal law. It basically says, where were you domiciled at the time of your death? And then what laws apply at the time of your death? And generally, my short answer to that question is, if you are a Kenyan, you had written your will in Kenya, perhaps you deposited with an executor here in Kenya, and you die in the US, your will still stand the test of scrutiny from a legal perspective. It can still be enforced, even if some of those assets are outside of Kenya. Because at the time of your death, you are a domiciliary of Kenya, you're a citizen of Kenya, and this is what you had intended. This is how you had intended your property to be distributed. And let's face it, with the way the world is positioned now, you can have investments outside of this country, but that doesn't mean that you have to have a will in every country in which you have invested. As long as your will is valid in the country of your domicile, in this case, Kenya, it will apply to property outside of Kenya. Now, the only caveat, and this is where, the more sophisticated your investments get, the more important it is also to get tax advice. You need to make sure that whatever taxes and liabilities are applicable in that jurisdiction are settled to the satisfaction of that jurisdiction before there's distribution, because your estate then will be responsible for those taxes and liabilities in whichever country.
Okay, so he asks again, at what age would you advise one to write a will? You
18.
Middle age, old age?
18. Basically, the Succession Act recognizes a will so long as, in addition to everything I said about, the form of it, this witnessing and all that, you have to be of sound mind and you have to be an adult. And in Kenya, the age of majority is 18, which means from the point at which you're 18, you have capacity to write a will. As long as you're not incapacitated by what the Act defines as either mental incapacity, physical incapacity, or, and they single this out specifically, drunkenness. So if you say something when you're not sober, If you write something when you are not sober and it can be proved that you are not sober, it will not stand then the test of validity. I want to then also talk about mental health, because this is a big, conversation in Kenya and across the world, certainly today. Your state of mental health can incapacitate you from writing a will, a valid will. If somebody can prove that at the time you wrote your will, you were not in your right frame of mind, maybe you are suffering depression, or maybe you are suffering some other mental health issue, then that will can be challenged for validity. So it's something we need to take seriously. I know, when we talk about mental health these days, people sort of shy away from the conversation, but you then begin to see how it can play out in different aspects of your life. So even your capacity to contract, for example, can be impacted by your state of mental health. So it's something we all need to take a little more seriously than we do.
Yeah, and also you've just reminded me about a famous family, I wouldn't mention the name, where some of the kids went to challenge the will on the basis that their father was on life support when he's alleged to have varied or written his new will. And so they were claiming that the widow, because this was their stepmother, that the will she had wasn't valid because he didn't have capacity to draft that will at the time that she claims he did. So I'm glad you brought that up, the issue of capacity, whether you're contracting or writing a will. Thank you. Must I seek a lawyer to draft my will? Can I draft mine? Will this stand in a court of law during the succession hearing, or must there be a lawyer stamp?
No, you don't need a lawyer stamp. You only need those two witnesses that I mentioned, who must witness you signing the will and, basically confirm that they saw you sign the will. And by the way, some of the case law that we have in Kenya, they don't even have to know that it was your will you were signing. They just have to have seen you sign that document, even if you don't tell them what the document is. So no, you don't have to go to a lawyer. Like I said, with increasing level of sophistication of your assets, then you may want to talk to a lawyer. And then because of the jurisdictional issues that have been raised in the 2 questions prior, you may also want to just consult and make sure that you've covered all your bases. But no, you don't have to consult a lawyer. Yes, it is advisable that you consult a lawyer.
Thank you for reminding them about lawyers, experts. So Queen of War, what happens to the wife or children of a business person who chooses to invest and write all his wealth under a holding company or trust? Is this so mean or legally accepted? And then she goes further and says, on a light note, when people board planes or sign into new jobs, one is compelled to state the next of kin. Isn't this so traumatizing to the traveler or the employee?
No, Queen, because remember what I said, death is inevitable. The minute we sort of remove the sting, and it's painful, but the minute you remove the sting from it, then you begin to think a little practically about some of these things. And, I know I said lightly that you should start writing a will when you're 18, but really, whenever you feel you're ready mentally is the point at which you should start to write that will. And especially as you gather more and more assets or have more and more touch points in terms of people you think you would want to benefit in the event of your demise, then you need to start thinking about writing a will. Now, this whole question about holding companies and trusts and, sort of what I said in the beginning around you start to plan your estate every time you sign certain documents. So even when you're setting up a company, and Helen will tell you there is a legal absurdity we have in the company's law, which allows a one person, me, Jackie, by myself, to start a company. I am the shareholder, the sole director, the sole everything. Which for me, the reason I call it a legal absurdity is what happens when you're gone. So it's really important, especially if you're in that situation where you have my own company, me by myself. You need to incorporate in your will. First of all, you need to write a will. Let's be clear. And you need to incorporate in your will how that company should be disposed of in your absence. Now, it's not necessarily mean. I think, Queen, the reason some people do it is because of certain tax efficiencies. For example, when you want to transfer property from yourself as an individual to the company, or for within other entities that you own as shareholder, then there are certain tax efficiencies to be gained in terms of capital gains and things like that. So sometimes those are the reasons that compel people. But it's just really important when you find yourself in that situation of owning a company to also decide how your shares in that company are to be distributed, especially the companies we own from an entrepreneurial perspective. The ones you own from an investment perspective, you will inevitably talk about them in your will, because we've already agreed that those are the things people count among their assets in terms of shares. I have shares in Standard Chartered Bank or whatever, and this is how I want them disposed of. But now when we talk about what you have invested in, whether it's your side hustle or it's a business that is now maturing, you even have maybe other investors, you need to think through who is supposed to benefit from your from your shares in the event that you're no longer there. And it can be more than one person, because remember, shares can be owned jointly by more than one person, but you have to make it clear in your will that this is how you want it distributed. So it's not just being mean, it's sometimes efficiencies in terms of how you own things from a tax perspective. I don't know if I answered both limbs of the question. The rest was a comment, right? Yeah.
Yeah, the rest was about, you answered.
Trauma.
You answered it actually. Started with that one. Yeah, you started with that one.
Okay.
Yeah, now Rosalyn's question, I think Rosalyn Odero, this one you have to pursue through the Law Society of Kenya. Because she talks about her grandma having left her will, she was illiterate, and the lawyer took advantage, and the lawyer is since deceased. So you need to pursue this through the Law Society of Kenya. How do you ensure that the lawyer does?
To avoid this kind of situation, this is why I said it's important to tell people you have a will. Number one. Number two, don't make your executor everything, right? Because how is it that the executor was able to go to the bank and withdraw money? Because I want to believe, unless the executor was also a beneficiary, the bank then should not have honored that. But like Helen says, definitely seek legal advice. Also seek, disciplinary, if you can, from the estate of that lawyer, which is when it gets a little complicated as well. But yes, don't hog information. Like you have to trust at least one person and tell them, I have a will. It is deposited with Jackie at Umsizi. So that Jackie at Umsizi, God forbid, does not decide to sort of transfer. And there have been cases where even land has been transferred to legal counsel in this manner.
Yeah. Okay, Julie Mzuri is asking, is there a time limit of executing a will? I think she means basically making sure that my wishes in that will are fulfilled, because she's talking about a time limit of executing a will and concluding on the same to allow the beneficiaries to settle down, because she says they've seen some take forever, and what would really be the issues in such a case. Each case is determined on its merits.
That's true.
So I think it's about how quickly should the executor work, and we'll get to that when we're talking about what advice you have. Remember the question you asked about whether people have experienced
the process of executing or enforcing.
Yes. Yeah. So we'll talk about executors and executrix, their role. Well, what kind of people would you recommend? So we'll get to that, Julie. The second part of your question, we'll get to it. You have a client. Can Umsizi LLP prepare wills for diaspora clients?
Yes, we can.
Judy,
but I'm not allowed to advertise, so I'm just going to say yes. I'm not allowed to advertise.
Yeah. So yes, Judy, you can contact her directly. Another question from Julie. Who is the best person or place to trust and keep your will for confidentiality purposes? We've just spoken about how you need to let people know you have a will. Julie, Jackie?
You know, this used to be such a straightforward kind of question, Helen. You would say, oh, you're a lawyer, you're a pastor. But you know, these days, trust is as good as the person. So it just has to be somebody of integrity, somebody you know, as I said earlier, will fulfill your wishes without judgment, and somebody who will not hide information from the people who need to receive it. So it would be useful then to, you sort of have to evaluate the people who are around you and then make that decision. It's really a sort of individual decision. Typically, people will go to their lawyer to do this for them, or identify a lawyer to do this for them. But what I would say is, you know, do your research in terms of the kind of lawyer that you're engaging with. What is their track record? Who has referred you to that lawyer? How did you hear about them? What are some of the stories, you know, that are associated with whether they deliver or not, you know? And you can also always request, for whatever it's worth, a letter of confirmation of good standing from the Law Society, for example.
Yeah. Okay, thank you. Christine Mutena, how do we address the case for having kids with disabilities who will never be independent? In Kenya, we don't have homes per se where they can be taken care of. How do we go about leaving a trust behind that will address their care?
Okay. So this is one of those examples, Christine, where I was talking, if you have something, a cause that you're passionate about from a health perspective, you can decide, for example, to channel your distribution through a body that you know takes care of, you know, for example, persons with disabilities, and make sure that, first of all, give a direct request to that child with a disability. And assuming, and I don't know if the disability is mental or physical, because then there are different, you know, conversations around that. But, you know, assuming that the child would be capable of accessing the benefit that you're giving them, then nothing prevents you from giving directly to that child or dependent, because they may even have passed the age of 18, but they're still dependent. So making sure that you cater for them financially, either directly if they're capable, meaning they have the mental capacity, or through an organization that is tried and tested and is able then to channel this distribution for the perpetuity of that child. And like you said, there are not many. So maybe this is a challenge to those of us who have a passion for that, to then start to think through what do we need to do to make sure that children with disabilities are taken care of in the manner that, you know, you're describing in your question.
Okay. There's a question here from Polycarp that I wonder whether we should park until we get to question 15, which was really about leaving an equal distribution to your dependents. So I'll pack it for that time.
Okay, okay.
Yeah. Or do you want to answer it?
No, we can pack it.
Good afternoon. We can pack it, yeah. Okay. His second question is quite interesting. Digital wills. Can I opt to do a recorded video instead of a written will? Does it satisfy or meet the threshold under the Law of Succession Act?
Short answer, no, it doesn't. I mean, it's really nice because, you know, everybody can see you and presumably confirm that it is you. But in this digital age of Photoshop and other, let me say, alterations that are possible, anything is possible. So under the Succession Act, we haven't reached that stage where we have sort of built in the security features of a digital will. So we're still relying on the oral, which I said is only 3 months valid, and then of course the written that needs to have the competent witness attesting. So we haven't yet reached the era of digital wills. However, just thinking through gifts in contemplation of death, like if you're on your deathbed and you record, you know, this is how I want to be with Helen ABCD. There are exceptions that will take care of that because, let me say, dying confessions is what they are called, or gifts in contemplation of death, have been upheld in this jurisdiction. So perhaps that would be the limited exception then to the question, and may fall within what you're classifying as digital wills. But generally in the Succession Act, either oral or written in the manner described.
Okay. So Polycarp, it doesn't meet the threshold, unfortunately. Jerry, I think you had answered this question. So if I have a house in the US, I can write my will here in Kenya and that will be enforced?
So Jerry, if you're domiciled, and that means that you're physically present in Kenya, this is where you reside, this is where you spend most of your time and effort, then it can be enforced. But remember what I said about the liabilities, the property taxes and other things that may arise in the US will still have to be taken care of in order to enforce the bequest to your beneficiaries.
Okay. And I guess Ruthie's question, I think you had answered it earlier about a beneficiary who may not be a Kenyan citizen. I don't think it matters as long as you're able to say my daughter domiciled in Texas or wherever. Yeah, and her name. Yeah.
Correct.
Yeah. So this would impose a challenge. This one, Judy, I'll share Jacqueline's info. Mutena, I think she was just clarifying intellectual disability. Okay, I think we are done with that round of questions. Somebody has asked a question here on Facebook. How can a public trustee help me in the case of grant of administration where there is no contest to a will and I cannot afford a lawyer?
The public trustee is, there's actually a whole act around the public trustee. And this is under the Office of the Honorable Attorney General. Yes, but they have a threshold. Who's the person who asked that question?
Somebody asked it off Facebook, Jerry.
Okay, so Jerry, the threshold is the estate has to be of a value less than, I think it used to be 100,000, I think it was up to 500,000. So if the value is less than that, then the public trustee can certainly assist. They have very specific, let me say, duties that are imposed on them by the Act. So they can receive property for administration, they can ascertain the proprietorship of those assets, they can ascertain who the heirs are, call in the assets, obtain consent for administration. So basically do everything, you know, that your lawyer would do on your behalf. So it's certainly possible, but just remember there's that threshold that the estate should not exceed the amount of 500,000.
And does this only apply in the case where somebody dies?
Without a will.
Without a will, yeah, because if they have a will, I don't think the public trustee would have jurisdiction. Yeah.
Correct.
Okay, so we'll move to, I think we've exhausted their questions. We'll now move to, we were on executors and executory. And I think you did tell us the kind of people we should look for when appointing an executor or executory. But we also read about, you know, beneficiaries and will going to challenge how these executors are, you know, managing the trust or mismanaging the trust. So would you say that there's need for training for these people, and how is this within our Kenyan jurisdiction? Is this something that is happening?
Yeah, so it's two things. It's the training that you've mentioned, and then it's also the integrity question, right? Because maybe I know what I'm supposed to do, and I think the question had been asked by one of our participants around how long it takes to basically execute a will. What are the instances that lead to the delay? And also the question I think that Maurice had asked about you know, this whole process of administration. It's not Maurice, Martin. Why is it that it can take so long in some instances, and then, you know, how do you make sure that it's fast-tracked? So the executor has very specific duties under the Law of Succession Act, and like I said, you know, you need to be looking really at persons of integrity, or indeed if it's a firm, then you need to ascertain that the partners within that firm, if it's a law firm, are able to execute. And it doesn't even have to be a law firm. Basically professions, even accountancy, for example. Some of them are corporate trustees, for example, who typically manage other types of funds, such as pension funds, but they also can serve the role of executor. And sometimes what people do, especially the more sophisticated your investments are, or the bigger value of the investments, is you have more than one, which in itself can be expensive for the estate, because remember, if it's a professional executor in the manner that I've described, then there may be some fees that attach to them in terms of the administration of the estate. And execution can take a very interesting form where it's just very straightforward, where they open your will, read it to your beneficiaries, and then make sure that, for example, the bank is aware and unlocks the money, the confirmation of grant is done, and then the beneficiaries can go about, sourcing all the different pockets of assets. Or it can be, and I think this is the question Queen was asking about, mean benefactors, where the property is entrusted to this executing entity. And then they are supposed to give, maybe if it's a monthly stipend or a monthly sort of allowance to the beneficiaries. That can also be a different form of trust. And the cost then of that administration, and you may have seen it play out in the public eye in terms of some of these really wealthy families, where they say even the costs of administration or the costs of execution are prohibitive, because they're eating into the actual gifts that were made to the beneficiaries. So if it's a straightforward thing, we fall back on the two issues I raised earlier. Do they know what they're supposed to do? Which is the question you raised about training. And like I said, there are entities that can undertake that training, whether it's legal firms, accountancy firms, or even private equity funds. But also, do they have the will to do it? What is their compulsion? So is it a question of they're being paid and therefore they'll do it professionally, or is it a question of because they were selected by the executor and maybe they agreed on by the deceased, and they agreed on a one-off fee? That fee is then paid once they have done whatever it is they need to do. And maybe these are some of the contingencies you need to build at the point of appointing your executor, where you say, at the point when you have finished doing your job, then you will be paid, or you will be paid against certain milestones. And I think that would certainly address this question of the slowness of execution. Because, for example, you could say, reading the will, 5%. Then different milestones around making sure that the beneficiaries are aware of the manner in which the assets that are distributed are to be dealt with. There could be another contingency built into that, or even making sure the final pay is pegged to conclusion of that whole probate process, and making sure that now the property is in the hands of the beneficiaries to do with what they want. It is no longer contingent on any action of the executor. Then you can decide any final balance is to be paid. But it's really the kind of questions that are coming through are testimony to the fact that those who have tried to enforce wills have also struggled in the way that these wills then are being administered. So your executor should never be too busy to make sure that things that need to happen are happening. If there's school fees to be paid, it needs to be paid. There shouldn't be any delay. If there are hostel bills to be paid, they should be paid without any delay. If there are any other liabilities that need to be paid, they need to be paid. And especially if there are liabilities that will then attract penalties. For example, if there are certain taxes that need to be paid, land rents, land rates, they should be paid, so that they're not attracting any penalties. And this is why I said sometimes it's useful to have legal advice at the time of writing your will, because depending on the type of property you have, you may have to build in these contingencies into your will so that the estate is not left broke or with additional liabilities beyond what the person writing the will intended at the time of writing the will. So also building some accountability into the will for your executor or executors, as the case may be.
Yeah, I lost you there at some point. Can you guys hear me?
Yes, maybe it was mine.
Yeah, I lost you there at some point. It showed my connection was unstable.
Oh, okay.
So basically what you're saying is we have to build in it's like a project, right? So there has to be certain milestones that if you accomplish this, then you get paid this and the other, so that then they are able to make sure that the will of the one who has departed is executed in time.
Mm.
So, what about training? Do we have training for?
We should.
For these
Executors.
I know we have a lot of training around retirement benefits trustees, but I've never seen any that is just dedicated to.
I think the trainings that do come about come through associations such as, for example, there's an entity in Kenya called the Family Business Owners Association or something like that. So they will invite people, but you see, it will be training in the context of you've invited a lawyer to come and speak to you, or an accountant or a tax advisor. But I don't know that there's any specific to executors, and maybe that's an opportunity then that USIU can. Helen? Salome, can you hear me? Okay, we seem to have lost Helen. Salome, can you hear me? Okay, Jerry, I see your hand. You wanted to ask a question?
Hi, Jackie, I can hear you. Helen got disconnected. Just give me a minute.
Okay, so maybe I'll take that opportunity then to answer the question that Polycarp asked. You said, must one leave something behind for their children? Is one compelled to leave inheritance for my children against one's wishes? So depending, Polycarp, on the age, let me put it this way. If they're over the age of 18, they are technically, legally not considered your dependents unless they have specific circumstances, for example, that make them dependent on you for longer. So for example, if they're incapacitated, physical or mental disability, then the period of dependency is a little longer. And in that sense, then you then have to continue to take care of them. But I'm sure you saw the case in the courts. Was it last year or the year before, where two, I think they were in their 20s or 30s, took their father to court to try and force him to bequeath property to them. And the court said, no, he doesn't have to take care of you. He has done his duty. He has raised you up to the point of majority. You are now adults. Go and fend for yourselves. So the short answer, you don't have to, unless there are specific circumstances that render them dependent on you for a longer period than is the age of 18.
Okay, thank you, Jackie. Sorry, I was bumped off. I had a question, and it's just to piggyback on this one you are addressing. I read somewhere that expressing love is a very good thing to do. And many of these people that we term as beneficiaries under our will equate the love they receive from their parents or the gift or whatever it is they'll be bequeathed with the parents' love. So would it be a good practice then to encourage parents or anyone that is leaving something to somebody under their will, not to do it unequally, and where you do it unequally, if you distribute unequally, let's say to siblings, is it okay if I write a letter to each one explaining the reason and making it clear that it doesn't reflect that, that I don't love them? Just that, the soft nuance.
The emotional intelligence.
Yes.
So, and I'm sure you heard my answer to Polycarp. You're not entitled to give children anything. You can decide that your love and affection for one child is different from your love and affection for another child. And you could have your own reasons. Maybe that child has struggled a little more in becoming emancipated and reaching a certain level of sustenance. So you want to support that one more. So, it's not necessary that it has to be equal, especially when people, are adults. Like I said, for dependents, you really just want to make sure that you continue to support them from beyond the grave in the manner to which they were already accustomed, to the extent that that is possible. Because remember, this is all dependent on what your investments were, what assets are available in terms of continued income to your estate, and then how many beneficiaries you have. Remember, in our act, I think it even talks about grandparents, step-grandparents. There are all manner of people. In the case of, if you don't have a will, could stand to be, you should have assets distributed to them in your demise. In the African context, your beneficiaries can be very many, right? But so depending on how you have decided, and this is why it takes a lot of thought. So yes, it may not be practical to write your will at age 18, but then as you grow older, as you mature, as your properties increase, as your beneficiaries also become a little, more, then you start to think through. Now, Helen, let me see, how long was she in university? When did she earn her degree, for example? Is she self-sustaining? Have I had to supplement her income every now and then? Maybe she needs more, maybe she needs less. Meanwhile, Jackie, took a bit of time to settle down. She had mishaps along the way. So I think I want to support her a little more. And also remember, there are some people who start to do this when they are still alive. So you'll find that maybe I have, let's say, 3 or 4 properties across the country, and I've already decided this one is in Helen's name, this one is in Jackie's name, the other one is in John's name, another one is in Salome's name. So already you have started to plan your estate, because you've essentially said, I've given that to you. You now deal with it how you wish. So because I've given that property to you, and depending on where the property is, I mean, if I've given one child a property in Karen, and then I've given another one a property in the CBD, for example, the value of that property is obviously different. So if you have already given you a property in the CBD, you certainly cannot be expecting that, anything else that I give to the person, the one who I gave property in Karen or Embakasi or anywhere else, should not then be brought up to a certain level, maybe to compensate based on that emotional intelligence that you're talking about. So this distribution is something that you really need to think through. And also, maybe you're thinking about who will take care of it. And remember, I asked the question at the beginning, should we care what people do with our assets when we are gone? Because honestly, you're gone. What they choose to do with them is entirely up to them. And you will find there are some communities where some of these things are a given. For example, the firstborn son gets the ancestral home, or in some cases, it is the lastborn son, for example. So there are some things that, and especially if you ascribe to those cultural, concepts, then there are some things that you will already have said, whether you've declared it or if there are titles, then the manner in which you have delineated those titles, you have demarcated and divided your plots and said this goes to so and so and so and so. You may already have, distributed them orally or verbally. And maybe that oral and verbal intention has already been declared in your will. So maybe not everybody will get everything. Then remember, until the Constitution 2020 came to rescue us, women did not inherit in the same way as men. They did not inherit from their parents in the same way, but that has changed. So even in the Succession Act, you will find that the way in which a wife can inherit from her husband is the same way a husband can inherit from the wife. So some of these cultural, let me say, imbalances are now being equalized through law. But I must say that sometimes culture takes a long time to catch up to the law. So you may still have a battle on your hands even if something has been bequeathed to you in writing.
Okay, so that addressed the question I had earlier about whether you can write out someone as a legal heir. Okay, now back to what can be bequeathed in a will. You talked about the fact that there was no limit. I don't know whether we talked about things that people associate with succession, but seem not to fall under the threshold of succession, like retirement benefits, for instance. Do I have to wait until I get letters of administration in order to be able to, as trustees, let's say, of a pension scheme, in order to be able to distribute the benefits in accordance with the deceased's wishes?
Thank you. And that's a very important question because, like I said earlier, estate planning sometimes starts way before we acknowledge that it has started. So if I take out, or if I'm a member of a pension scheme, and when I became a member of that scheme, and unfortunately for Queen, I was asked to name a beneficiary or name a next of kin, I have already indicated some level of distribution. So either I'll say Helen 100%, or I'll say Helen 30%, Jackie 40%, and the balance 30% to John, right? So from the trustee, that pension fund trustee's perspective, that is what is going to happen, irrespective of whether you've said something else in your will. And this is why it's important when you're writing your will to have reference to anywhere you've ever mentioned or nominated a beneficiary. And typically in the realm of life insurance policies and pension schemes, it's really important to make sure those things speak to each other. And if you're a member of a professional body as well, you may be asked to nominate a beneficiary. If you're a member of a circle, you may be asked to nominate a beneficiary or beneficiaries and confirm how you want that distributed. Those types of entities will basically take that beneficiary form as them sema kweli. That is all they will go by. They will not care whether there's a process of administration. They do not get into that. So it's really important that if you want to change your mind somewhere along the way, make sure that all that is effected in those beneficiary forms. So like in answer to your question, Helen, those people don't have to wait for the distribution process by way of confirmation of letters of grant. They will go by what is in the nominations. And remember, this becomes important. For example, with life insurance policies that have a death benefit, they're not going to wait. They're not going to wait to pay, for example, your last expenses because they have now fallen due. The trigger for the life expense is your death. So they're not going to wait until Helen and Jackie have come forth and said, we're also dependents. No, that will, kick in immediately. So really important to pay attention when we are filling in these beneficiary forms.
Yeah, you've raised something very critical, that they will not pay attention to whether, I have a will that says something different. But what about where they overreach their, I'd like to call it their mandate, and they do so taking into consideration the fact that this deceased person went and had another family, and their minor children or their children who are dependent on them, who are not included in this nomination of beneficiaries form, and therefore the distribution doesn't cover them or their mothers, okay? Then you find that trustees actually make a decision to redistribute the benefits so that the minor children are able to continue going to school. Would that be open to challenge by the first family? so to speak.
And I've actually seen this in practice from my experience in insurance. And several things can happen. It depends on the approach that the family takes. In some instances, if, as much as it pains me, I am aware that you are the second wife, Helen, and you have children. I'm the first wife, you're the second wife. We could just decide to come to an agreement. And then a distribution is done so that my children or your children can also go to school. What also I've seen happen in practice is a challenge in court, where you say, yes, this is how this person had nominated that, and they never updated their beneficiary form, for example, to encompass the new dependents. But I have seen instances where that beneficiary form is then sort of paused, and the process of administration through the courts is then necessary. And why is it necessitated? Because the courts, or indeed the public trustee, have the power to determine beneficiaries. And that power to determine can take God knows how long, possibly a minimum of 2 years. So what is happening in the course of that time? And sometimes, and again, dependent on the kind of legal advice you're getting, you can actually seek a limited grant of administration. And that limited grant is to enable then the payment of school fees, the payment of hospital bills, and sort of emergencies that have come up while we're still determining who are the proper beneficiaries. So different scenarios play out, of course, depending on the circumstances. People can agree to, yes, I am the valid or validly nominated beneficiary, but because I am aware that you are also a dependent, then I will make sure that out of the estate that you're also getting a certain amount on a frequent basis. Or that whole process could be stopped and we could end up in court. And even whilst we're in court, there could be a limited grant that is given on a proper application to make sure that people are still going to school and people are still being taken care of.
Okay. There's a question here from Jerry. I think you've answered this question in several ways.
About
parents leave everything to their corrupt pastor.
Wait, I'll come to your second question, Jerry. Jerry, your first question, you're saying dual citizenship, which is now important because we never considered it in the past. Assuming you're a citizenship by naturalization in Kenya, then that will be a factor in determining your domicile. So you will still be considered a domiciliary of Kenya so long as you have that dual citizenship. Then in terms of your second question about the corrupt pastor. So you have old parents, they left everything to the corrupt pastor and give the children what is legally possible to get away with. Can the children appeal the will? You can. And to the extent then that you can show, you've put corrupt in brackets. So which means it's an allegation maybe that needs to be proved. And if it can be proved that there was some element of duress or there's some element of undue influence, then as the children, you can certainly contest that. And depending on the evidence that is available, you persuade the court that gift to the pastor was given when your parents were not of sound capacity to give that gift, so to speak.
Thank you, Jackie. Wow, so much to learn in so little time. We have 25 minutes left, and I thought we could dedicate these 25 minutes to any new developments in the area of estate planning that we need to know about, either from the Kenyan or international perspective. And Salome, we can allow someone who wants to ask a question to raise their hand, and we can allow them to speak if there is any, as Jackie gathers her thoughts around, new developments.
Okay. And whilst you do that, I had seen a comment in the Q&A where I don't know if we shared the third poll question or we just shared the results of the first two poll questions. So if we didn't launch the third poll, maybe we can launch it now. So new developments. Estate planning is one of those areas that is so deliberate. Like you have to be so deliberate about what you want to do and how you want to do it. I would say the new developments I had sort of alluded to earlier about, thinking more about what we count as assets. So things that we didn't traditionally think about because we were maybe from the so many Vijana generation where we were encouraged to get proper jobs as opposed to jobs in the creative industry. So you start to think through what your assets might look like beyond just the cash and cash equivalents, but also in terms of there's always this back and forth around, and I think some of the participants alluded to it around, is it just best to bequeath, your beneficiaries directly, or do you need some entity, especially, if you have quite a bit of wealth? So is it a question of just give to Helen directly, or do I need a trust to set up? And then, and I had mentioned it earlier, how is this trust going to be administered? The law of trusts in Kenya is evolving. Registering a trust is not that straightforward anymore, perhaps because of the reasons that I mentioned around perpetual succession, the things that people the trust is in perpetuity. So even when you want to register a trust, there is an element of scrutiny around your trustees. So there will be some intelligence that will be gathered around the people you want to put as trustees, the people you want to establish as trustees. So it takes a while. It's something you don't do in haste, and it's something that perhaps should go alongside your estate planning. So even as you're thinking about writing your will, part of your estate planning is at what point do I start to trigger the trust, so that maybe you are one of the inaugural trustees, one of the founding trustees, but by the time you're gone, there's already an established way of the trust operating, especially if it's for these charitable purposes, and especially if it's for a cause that's close to your heart, like the one that we mentioned around taking care of children with disabilities or dependents with disabilities. So I would say start thinking through your legacy, and I don't mean legacy in terms of big for agenda kind of thing, but in terms of what it is that you want to leave behind and who you want to leave it to, in whose hands is it going to be, which is the safe pair of hands that you can trust. You need to look around your circle and figure out who are these people that number one, can just be witnesses. But number two, most importantly, these executors. Remember, the executors have quite a significant role to play. They are literally your personal representative who you've appointed under the will to give effect to your wishes. They have to keep proper accounts. They have to identify your beneficiaries. They have to pay any legacies in terms of cash or specific gifts. They have to pay the debts and liabilities. And then I had said I'd talk about this a little later. I talked about the residue of the estate. So after your debts and liabilities have been paid, any legacies that are to be given have been given, any trust has been, encashed, you've basically put cash in the trust. What is left and how should it be then dealt with? And the proper way then should be that this residual income, you really should indicate the manner in which you want it to be distributed. So if you're inclined to set up a trust, then let that residual income go to the trust. If you want to finance any charity, let it go to that charity, or let it go to a project that you're passionate about, or let it go to an individual that you're passionate about in the way that Helen had described. We sometimes have favorites, but don't leave anything hanging, because anything that's hanging is then up for grabs. It's like those dormant accounts in the banks that nobody is taking care of. And actually, let me then talk about, because I'm privy to the functioning of the Unclaimed Financial Assets Act, let me talk about that. The Act came into effect in 2011, and then the authority was established probably the following year, so 2012 or thereabout. And the purpose of the Unclaimed Financial Assets Act is really to make sure that assets belonging to deceased that are not accounted for are safeguarded and then eventually reunited with the beneficiaries. So maybe you had a bank balance in Standard Chartered that you forgot about, or maybe your parents or your grandparents, had that original passbook, but somewhere along the line those things disappeared. Nobody has even remembered that they had an account there. Those assets are supposed to be remitted to the Unclaimed Financial Assets Act. And let me describe what financial assets are under the Act. It is cash, So cash at bank, for example, it is the benefit of a life policy that has not been claimed. It is a check that was not presented. And, you know, things even we don't think about, like your M-Pesa balances, like I talked about earlier. And each of these sort of classes of assets have a time limit. So if they've been in the bank, for example, for 2 years, or a check has been unpaid for 2 years, nobody has claimed it, that asset is supposed to be declared to the authority and is supposed to be remitted to the authority. Even shares, maybe you haven't claimed dividends, and you know we have different reasons for not claiming dividends. Maybe your average dividend was 30 cents and you didn't see the point of claiming dividend, and it ends up at UFA. So I want to make it very clear to everyone that that asset, as long as it is at UFA, is never going to be lost. Whenever you come forward as a bona fide, genuine beneficiary, or even the actual holder of that asset who sort of disowned you or abandoned your asset, as they say under the Act, you can claim that asset forever in perpetuity. What you will not be able to claim is any interest, because what the authority does, they invest those funds, and then that investment income is what funds the operations of the authority. Now, once they've invested those funds, they have a duty, which you know your bank had or your insurance company had and they didn't fulfill, and that is to look for you and to reunite you with that asset. So until you come forward, that asset is available for you to claim. So sometimes, you know, don't feel that all is lost when, for example, you know that, you know, somebody you loved had left some assets in such an institution and you feel that it is lost. That asset will never be lost, for example, for as long as it has been remitted to the Unclaimed Financial Assets Authority. I just thought I'd mention that because I know those questions come up a lot, but nobody maybe is either familiar with the authority or has had the opportunity to engage. And I know they now have a searchable database, both on their website and there's a, what do you call that, USSD code that you can key in and then check through your ID or anything whether you have any assets at UFA. In fact, let me just put.
So what about T-bonds? What about T-bonds?
As unclaimed financial assets? Yes, those also qualify.
So the CBK falls under the ambit of this act also, right?
They do. Now, obviously, there are some acts that are in conflict with that act, but the UFA Act is supposed to prevail over those acts. So you will find, for example, there's a push and pull with pension funds or even life insurance policies, because there's a way that they traditionally dealt with those life insurance policies that are not claimed. So there's a conversation, I'm aware, that's going on between the insurance industry and the Unclaimed Financial Assets Act in terms of making sure that those assets are properly classified and then at the time of agreement remitted to the authority.
Okay.
Yeah.
Thank you. I had a final question. We had talked about revocable and irrevocable stuff. And I'm curious about, what if these executors, how do I remove them? If they are really wasting away the estate and they just go rogue, how are they removed?
Unfortunately, through a court process, because obviously, on the one hand, it was the intention of the deceased that should be the person or the entity that was administering the estate, and then on the other hand, there's you as the beneficiary claiming that they're not doing their job. So unfortunately, it's a court process you go through. You obviously have to present sufficient evidence and satisfy the court that, and there will be evidence maybe through accounting records or any other timelines that have not been met that you can then present to the court to have the executor removed.
Okay, thank you. All right, is there anybody who has a question? They can raise their hand. Salome, did anybody raise their hand? John.
Yes, I was checking to see if there's anyone who's raised their hand. I can't see any, so I've decided let me probably begin. So I just wanted to find out, can my will be valid if I have decided that I want all my assets all my properties liquidated, and then now shared out in the percentages I will decide. Would that be
Yes.
a valid way?
Yes, it's valid.
Okay, good.
Any other?
No, the rest have been answered.
Okay, so nobody else's hand is up. Any parting shot? Oh, there's somebody's hand that is up.
Jerry.
I can't see from this end.
Should we allow to talk?
Yes,
Salome?
I've allowed her,
Jerry?
she can talk.
Okay.
Based on your experience, is it worth fighting for a will or just let go? Because we've seen people spend years upon years, and I think that's why most people don't even want to use lawyers. I have nothing against lawyers, but would you advise people to maybe sometimes just let go of the property and maybe just have peace without fighting for years upon years? What's your, I don't even know whether to say professional or emotional based on that?
I'll give you, Jerry, a combination of both professional and, let me say, human. There are always ways to resolve a dispute. And I don't know if you had the introduction, but I am quite heavily involved in alternative dispute resolution. And some of the cases that come before us in mediation are succession disputes. And I think mediation is a very healthy way of exposing the issues between two or more sides and then coming to a middle ground. Because what mediation does, the mediator, because you'll bring in a third party just to help you have a conversation and have let me say, a professional fight. The mediator does not give you a solution. The mediator will facilitate this negotiation and help you think through possible scenarios and say, okay, Jackie, you're insisting that Helen should not have the house in Embakasi. What are you proposing? Are you proposing that you own it in equal share, or what are you proposing in terms of how, or should you sell, like, the question John asked, should you sell and then you share the proceeds, or what do you propose? So the mediator will help you think through solutions. And I think it's a much healthier way than even giving up, for one, because if you give up, then is that a happy situation for you to live with? Will it bring you peace, or will it buy you peace in the short term, and then in the long term, just generate the possibility of future animosity? So it's useful to explore to the extent that there's a relationship worth preserving, whether it's in the family context or even in a commercial context. Is it useful to then sit around a table and sit with a mediator and help you then unlock this process? And the beauty of mediation is there is what we call ad hoc mediation, which is the parties can just agree to start the mediation process, or even if a matter is already in court, the court allows a path to mediation, what they call court annexed mediation. So your matter could already be in court, maybe it's a succession cause, but you then say, look, this is taking too long, can we please consider a different way? So that avenue is certainly open to you. And even if it takes 6 months for you or more for you to agree to come to the table, at least hear each other out and then agree on what's the best way forward, not just for perhaps your generation, but even the generations to come. So this is both a legal response and also a human response.
Yes. Thank you, Jackie. I know there are judges in particular who really just send mediation, because family disputes are very, emotional and really sensitive. Yeah. So you want the family itself to come to an agreement as opposed to being the one that's imposing. Yeah.
Yes.
Thank you.
And then of course that agreement is legally enforceable. So it's something that if it's not honored by one party, you can still follow such enforcement.
Okay. Thank you. Judy Sultan her hand is up.
Yes.
That will be the final question we'll take. Thank you.
It's more of a comment. This has been very informative and very educative to something that a lot of us fear, because in the African context, when you're writing your will, it's like you're I don't know what the right term, you're inviting death. However, having said that, this is very good. And I think, please, I know you're recording it. If you could find a way to send the information, because there are some of us who were in the diaspora who would maybe want to get in touch with Jackie or even learn more about estate planning. And I think this is it would be a great resource for us to reach out. So thank you so much for putting this together.
Sadly, we've come to the end of this very lively and informative conversation. Thank you everyone for joining us today and being very engaging as an audience. Salome, do we have the poll results before we say goodbye? What are the poll results?
For the third question, because the one that keeps coming up is question 1 and 2.
For the third question.
Yeah.
It was, have you been involved in the process of enforcing a will? 29% say yes, 71% say no.
Okay.
But I see an overwhelming majority believe that it is necessary to have wills. So if you are part of our audience today, go and get cracking immediately. You have had the benefit of getting all this information. And also tell a friend to tell a friend so that we have more of us aware about the necessity of having a will and making sure that we plan for our transition while we are still alive. I know Jerry said that, no, is it Jerry or Judy? I said it's almost as if it's a premonition of death. I'm about to die, so let me put my affairs in order. That's how we view it as an African society. But it's good when we plan ahead and ensure that our affairs are taken care of, even when we are absent from this world. So thank you very much, participants, and thank you to our facilitator. If we could be able to clap for you, we would all clap. Thank you, Jackie. And thank you, Salome and John in the background, always making sure that we are on the social media platforms actively. And on behalf of USIU Africa, asanteni sana and kwaherini.
Asante. Thank you, everybody.